Welcome everyone, and thank you for joining our live webinar. Myself, Rudolph D'Souza, founder and president of MyNation Hope Foundation. MyNation Hope Foundation is a registered NGO. We have 10,000 members. It's not only for men. We help many women also because they said they are not getting any help from NCW or WCD. We have valid proof on that also. Because NCW and WCD is getting around 25,000 crore funding from government yearly. But when some aged woman approach them, they will say they are not coming under their mandate. So such women and families also approaching us, and we are helping them and guiding them for free. Today we are starting a new section called Men Ki Baat, because in India, men and his family has no laws to protect them. Government is not interested to listen to them. And no one is talking about men's issues, nor media is not reporting any men's issues. They only after women, women empowerment, Beti Bachao, or all funds schemes only for women. Nothing is there for men. So today we are starting new talk show. We are discussing about men's issues, the false cases they are facing, and their problems. Today we don't have any guests with us. Next week onwards, we are bringing guests. Whoever wanted to discuss their case, they can come forward and join us. We are happy to present their case. We are not bringing like others, like trained, brainwashed, or with money, nor prompted anything. It's real case. You can search on Google or NCRB for the false cases men are facing. Such men, whoever is facing false cases, can come forward, join us, approach us, register with us. We'll present their case in front of the public. They are not prompted, okay, or scripted or directed by anyone. It's free talk. They will present their case. That's what we are covering under Men Ki Baat. Anyone is interested, please approach us. Okay. This will be just introduction for today. Next week onwards, we will present one case every week. Hereafter, Dr. Vikas Singh will continue this webinar. Dr. Vikas Singh, please continue.
Thank you, Rudolph, sir. So today we have session on Indian Evidence Act. So that is, this session will be given by Mr. Raghav. Mr. Raghav is a software engineer and law student. He is also member of MyNation. Mr. Raghav is fighting against the gender biased laws and system. In this fight, he took up the study of law. He is going to share his learning about legal issue and which men face and possible choice which each one we have. So I would like to welcome Mr. Raghav to start his presentation. Thank you.
Good evening, everyone. I'm Raghav. On a Sunday evening and with the Men Ki Baat initiation today, I'd like to present a small intro on Indian Evidence Act. So first disclaimer, MyNation, these are only for education and advisory purposes. They have to be corroborated with facts and circumstances of each case. Relevant judgments can be accessed from MyNation website. and MyNation doesn't ask money. Please be aware of any such acts. Thank you. So this is an attempt at Indian Evidence Act 1872. So the agenda, I try to put it within the 60 minutes. So we start with history of Indian Evidence Act. Then what are the relevant sections or parts in Indian Evidence Act? So first one is about section 1 to 4. It defines about the preliminary things about Indian Evidence Acts, like the definitions in it. What is a fact? What is an evidence? What is a fact and issue? What is a document? What court? What is meant by court? Uh, those aspects. We'll go deeper into that in a while. Then we have relevancy of effects. So you in Indian judiciary, which is an adversarial system, uh, the person who wants to prove a fact has to make that fact first to be brought onto the records of the court. Only then that information can be used to decide his case. Otherwise, it won't be used at all. So this is a very important first part in any criminal trial or any civil trial, to bring any document or witness onto the records of the court. Without that, nothing can be moved forward. So section 59 to 60, which is an oral evidence. Oral evidence is the best evidence and which is direct, not hearsay. Let us say I am a witness to certain act, and if I come and be one of the witness for the prosecution, my evidence trumps over others because I am a direct eyewitness and I am giving an evidence for such fact in issue. There is something called documentary evidence as well. Documentary evidence can be any sale deed, marriage certificate, date of birth certificate. It could be any property document, many of those. So documentary evidences can also be electronic evidences. For example, any email, any CCTV footage, any videograph, any photo. There is a process under 65B which was introduced through Indian Information Act 2002. Uh, then we have something called burden of proof and presumptions. So generally, whenever a person initiates a criminal or a civil suit, the burden of proof means or is on him. That means he has to prove that there is a issue, and he has to provide with the facts of the issue and make the court believe that there is a case which is against him, and he is asking for a pecuniary or economic relief. And there are something called presumptions. So not everything can be proven. There are certain presumptions. For example, let us say there is a person who has killed a person and has a knife in his hand and comes out. So it is assumed that he was the last person, he is the person who could have killed. So that's a presumption which court makes to actually make the process of trial process quicker. Means there are certain presumptions which are very evident, but again, there are exceptions to that. Like court can allow you to bring evidences to dismantle those presumptions. Those are also there. Then estoppel. This is one of the beautiful things about Indian Evidence Act. For example, you have admitted something saying that on so and so date I was there. But going forward in the trial process, while giving evidence or being cross-examined, if you go back on your statement, it can be taken as you are stopped from making such statements. You are asked to shut up. You cannot go back on the statement which you have admitted. So you have to be very careful when the kind of evidences, the kind of information you put on record in the court. Like Chapter 9 deals with witnesses and privileged communication. So witness can be anyone, but there are certain communications which are very privileged. For example, between an advocate and his client. A client can be very truthful to his advocate regarding all the events of an offense or an act, but such information cannot be used against him in a trial process because advocate and a client is a privileged uh, communication. Similarly, between a husband and wife, so that communication also is not allowed as being one of the evidences. This is one of the core part of Indian Evidence Act, which is called examination of witnesses, where you actually bring out all the evidences, you cross-examine the witness, you actually provide counter arguments, you try to discard the credibility of the witness, you try to totally dismantle the case. It gives you all the tools here to bring on a witness, to bring on multiple witnesses, to bring on counter witness. Here you could actually identify someone as interested party, independent party, corroboration of evidences, so many things you can do. So coming to the history of Indian Evidence Act, Stephen's Commission was made in 1871, and it was headed by Sir James Stephen. He has drafted the Indian Evidence Act. He was also the author of Code of Civil Procedure Code, which was amended again in subsequently. So this draft was made considering the needs of India. Even before that, there were other what you call Indian Evidence Act, which was used by the presidency councils of Bombay, Madras, and Kolkata, but they found it was not matching the Indian needs. And this particular draft is considered as the best draftsmanship skill because it was adopted even before the constitution was enacted, and for the past 140 years, it stood the test of time and it is still relevant. There are some additions given the advancements in technology, for example, the Information Technology Act 65B, and certain other provisions like 113A, 113B, 114A, where the presumption are added to that given the needs of the society. So, what does law of evidence determine to begin with? First of all, why do we need a law of evidence? It has four things. First of all, what facts are involved? What is that you want to decide on? For example, there is a case, there is a murder, or there is a rape. That is the first substantial law. So there is certain offense under IPC which was is coming under question here. Next, what proofs should be are used to establish that fact? Okay, there was a murder. What weapons were there? Who were the witnesses to it? When did it occur? Where did it occur? So what are the proofs you have put forward to establish such fact? Did you put forward a death certificate of that person? Next, who has given the proof? Who is the authority who has given the proof? Did the doctor give? Did any person who is related to the person has given? Who is the proof? The factors, all this factor becomes very important in weighing the quality of the evidence. Then how should it be done? So Evidence Act gives you a procedure under which it decides or it provides you paths through which you could add, bring in evidence onto record. So it will be dealt subsequently. So there are three important aspects about fact: relevancy of a fact, how relevant is the fact, proof of the fact, with what evidences you are going to prove that this is a fact, and how it is admitted into the court. So chapter 1 and 2 of Indian Evidence Act deals with these facets: fact and issue, relevant fact. So chapter 1. So where, first of all, we need to understand where Indian Evidence Act is applicable. It is applicable for all civil and criminal judicial proceedings. Remember the word judicial proceedings. It is not applicable to any departmental proceedings where you have disciplinary proceedings or non-judicial proceedings and tribunals and arbitrations. Like, let us say you are in there is a mediation going on between two parties, husband and wife in a mediation cell. Indian Evidence Act doesn't apply there. This is one of the core piece of Indian Evidence Act, Section 3. It defines the terms. What does court mean? It includes all judges, magistrates, and persons in them. Fact. Fact means and includes anything perceived by senses. When you mean senses, what you can hear, breathe, see, touch, feel, and mental condition of which a person is conscious of. I feel that this Vijay Mallya is a rich man one point of time. That is my understanding of Vijay Mallya. I feel Narendra Modi is a great leader. So that is one perception. So that is considered as a fact. A relevant fact is a fact where one fact is relevant to another fact if they are connected to each other. For example, uh, I saw a person walking the street. So he walking is one event, I seeing is one more event. So these two are connected. Fact in issue. Fact in issue is such a fact where if there are two parties, there is a conflict between what the fact is. One party says this happened this way, the other party negates the way it was told about. So this is the fact and issue which is decided by the court. When the civil court or a criminal courts, in a civil court, they frame issues. Those are the facts and issues. In criminal cases, the court identifies, okay, you have committed this offense under this section. So are you eligible for this punishment or not? Based on the evidence you collect and prove in the court. Document. So anything which can be expressed in forms of figures, marks, on any surface which can be recorded. So document can be a paper, it can be a slate, it can be a cardboard, it can be a wall, it can be even electronic means. For example, on a tape recorder, on your phone. These are all documents. And documents are very important pieces of evidences. Uh, so till now we have gone through what is a fact, which is perceived by our physical senses. We understood what is a document. Now we have to understand what is an evidence. Evidence means and includes, there are two types of evidences. One is the oral, another is document. Oral evidences are all those statements which the court permits to be made before it by the witness in relation to matter in inquiry. So it is very specific. It has to be in relation to the subject which is inquired into, and the court should allow it. And documentary evidence is all documents, including electronic evidence, produced for the inspection of the court. So if you understand, evidence is that which the court allows it to be part of the court procedures. Anything other than that is not an evidence. It is not at all useful. So what is a proved fact? So this is so courts don't have a very high bar to consider something as a proof, a low bar to consider something proof. So what fact, a fact is said to be proved when the court believes or considers existence so probable that a prudent man, like a common man, under those particular circumstances, acts upon them as if they exist. For example, uh, I go on a road, there is a traffic signal, and the traffic signal was green. I, as a prudent man, I saw it is a green in color, so I walk. So if someone says that, why are you walking? I can say him, it is green in color, so it's a traffic signal, it's allowing to walk through it. So now when this issue comes to the court and the prosecution comes and tells, why did you walk before it? Walk while there was a traffic signal. Then as a prudent man, I know that there is a green signal. The signal is green. There is a corroboration of evidence, and I am walking because there is a green signal. So under those circumstances, it is this is the way we prove that the fact is proved for any common man. Similarly, something called disproved, it's reverse. If any common man, if he uh, acts in the belief that it was not supposed to be done, but still does it, so that is not proved. There is a gray area where you can't decide where it is proved or not proved. So that is where court can apply discretion. Classification of evidence. So there is something called direct. Direct in the sense, I am the eyewitness. I can come and stand in the witness box and give my evidence. Circumstantial. I have there is a person who has heard about me walking to that place. He says that, okay, I've seen this person walking across the street after this event. Similarly, there is one more person who says that, yes, he has reached at this place at this time. So if you see, there are two events which are corroborated with each other, and there is a circumstance which is forming a chain of events. through which you could say that this person had been at this place at this time and he reached this place. So generally, direct evidence is the best evidence to prove. If it is not provable, then circumstantial evidence becomes one of the substantial ways to convict or acquit a person. If you don't have a, because in our criminal jurisprudence, a person has to be proved guilty beyond reasonable doubt. Mere circumstantial evidence is not enough. It should be such that there is no other hypothesis possible other than that event. Real and personal. Real is, for example, I stab a person. I have a knife with. I have a knife which I used. That is a real evidence. Personal is a person who sees me stabbing a person. He is the personal evidence. He can come and be a witness in the court and give his statement. So original and unoriginal evidence. Original is like, for example, you have your phone. You have taken a picture and you produce that phone to the court. That is an original evidence. But let us say for some reason you lost the phone, or phone is in the custody of police, but you have that photo. So that is not original. That's a secondary evidence you have. Substantive and non-substantive. Substantive evidence is one wherein which court can decide if the person has done or not done a offense. Non-substantive is something which court cannot use it at all. It will actually throw it off. Positive and negative. Positive means yes. When there is an evidence speaking that yes, this guy has done this offense, that is a positive offense. Similarly, there is something called negative offense. For example, alibi. You are not at such place. So if there is a witness who can come forward and say, at so and so point of time, uh, as per the FIR, you were there, but there is an alibi. For example, your friend or a relative, or you're in a hotel saying that no, you were at some other place. That becomes a good evidence for you. You're negating the position there. You're saying that I was not there at that place. Uh, and prosecution and defense. Who introduces the evidence? The prosecution. The prosecution would be the state. If it is a criminal case, it has to introduce the evidences which it has collected as part of the investigation under the charge sheet, like under the 173 statements, the 161 statements, and whatever material objects which it has actually was able to discover as part of its investigation. Defense evidence is one you or person who is accused can provide. For example, the alibi scenario we had discussed. You could provide a documentary evidence, or you could provide your call data history or your location history, saying that no, I was not there at that place. So one last thing is regarding hello. Yeah.
Yeah, Raghu, you continue. Actually, we have some questions on YouTube. After this slide, we will actually take them.
Sure. So generally, it is understood that will the delay be a good ground for not accepting an evidence? Delay is not the only ground. It cannot be the only ground to discard the evidence. But if the evidence is cogent, useful, then delay can be sidelined. But yeah, Ramesh, can we go ahead with the questions? If you want.
The first question is from Survey Palli. He's asking what is meant by adversarial system.
Yeah, so India follows adversarial system, wherein which it's like a battle. You're in a boxing ring. You have two people. You fight between each other, and whoever is able to punch more and knock the other guy wins. So in adversarial system also we have a prosecution and defense. So the state, which is the prosecution in a criminal case, brings forward your case under an offense, let us say 376 or 498 or 302, whichever the case or offense may be, and it actually adduces the evidences also. Now, it will actually prove to the court that you were the person who has done this act. Now, you as a defense can cross-examine and discredit all the witnesses, all the documents which the prosecution has laid before the court. In this way, it's a battle between two parties. because of which it gives you a equal fairness to the defense, because you are fighting against a state which is very powerful in terms of its resources. So it gives you a good opportunity to a person who is accused to defend himself properly. That is the use of adversarial system, but there is a negative on this. The conviction rates are very bad due to whatever smartness or legal loopholes. That is one of the criticism adversarial system has. The other one is inquisitorial system. We can take it later in another discussion maybe.
Okay, Raghav. Yeah, the next question is from Aman. He asks, what is the difference between oral and documentary evidence, and which one is better? Like, which one
So,
has more merit?
so oral and direct evidence, not just oral. Oral evidence is a person who is a direct witness to an event. That means, I let us say there is a murder of a person, and I was happened to witness that event. Now I come and uh, tell in the witness box saying that I have seen this person commit a murder. It has more weightage than any other form of evidences. But there is something called hearsay evidence. Let us say I just told something to someone XYZ that, see, I saw a murder at that place at so and so time. Now that person coming and telling to the court is considered hearsay. Means he heard from somewhere and speaking about it, and court generally doesn't allow it. But if it was able to corroborate with some other pieces of evidences, like other direct evidences or other circumstantial evidences, it can be taken. The other form of evidence is documentary evidence. Documentary evidence, again, there can be many questions which can be raised on it, but oral evidence always triumphs on the documentary evidence. The documentary evidence can be provided by the accused. There can be also expert documentary evidences. There could be call records, which are also documentary evidences. Yeah, I think I've answered it.
Okay. Yeah, Raghav. We'll move on to the next question. Amit is actually asking for, can you please explain the difference between burden of onus versus burden of proof?
Wow, nice question. I'll come to it with time, I guess, but I'll just give it a simple thing and I'll move forward. Burden of proof is on a person who has to prove to the court his case. If he doesn't prove it, he loses the opportunity to what you call whatever position he has put. He will lose at that point. So that is a burden of proof on him. But burden of onus is, there is a situation where I can shift the burden on someone else to prove. For example, say something called general defense. In uh, in in criminal cases, the prosecution has to prove beyond reasonable doubt that the person is guilty. But there is something called general defense where a person can say that I was insane, I was infant, or I was unconscious, or I was actually drinking, or it's a trivial case. So when you claim these kind of general defenses, the onus shifts on you to prove that you are in that state. But to prove that, it's just probability is required. Probability of or possibility of probability is required. That is, you just need to say, you just need to satisfy the court that there are two possible events, either this or either that. And court, if it has a doubt that okay, he was able to prove that there is a doubt that he was not there at that place, or he was really drunk at that place. There are two possible situations arising. Then he has succeeded in proving the onus of his burden. Yep, going forward.
Okay. Yeah, we have next question from Ravikant, who says like he has an evidence recorded on his mobile and saved it to pen drive. His mobile is not working now, so can he use what is stored in the pen drive as evidence? Like, can this be submitted to the court?
Yeah, so you have for that, first of all, that is called secondary evidence right now, because it's in the electronic format. You have to follow the process of 65B, where you have to produce a certificate claiming that this particular electronic record has not been tampered with, and it is in the state which is, and you can submit to the court where the court will admit it. But the court can always put a question on you saying that the relevance is not decided yet. So it is just admitted onto the records. So it can be used as an evidence, but there can be questions arised on the authenticity of such document. So it can be sent to an FSL, means forensics lab, or any other lab which actually authenticates such devices. So it's again the discretion of the court. Court has huge discretion in this. Court will allow with a certificate of 65B, section 4, 65B, subclass 4.
Sure, Raghav. Yeah, the next question is on the call data record, can it be considered as a evidence in cognizable offense 313 IPC?
So first of all, when you say evidence, the court has to accept it. If you are able to satisfy the court under the admission under 5 to 55 of the Indian Evidence Act, yes, it can be used as an evidence to prove that you are at so and so place using the call data record.
Okay, and there is an additional question on this thing, like what is the max period of CDR we can get from the service provider? So
Okay,
yeah, this is not
that is
relevant to IEA, but
that is beyond the remit of the talk, but still I'll just get so maximum period is 1 year, but recent judgments have told by the court that there is no time limit. So because we are in a digital world, the data is always there. It is onto a tape record or a secondary storage medium. So these records are available, but you need an explicit court order to extract them out.
okay. And the next one is when it comes to email as evidence, does the content of the email needs to be proved as well, or the email in itself is considered as proof of the alleged incident?
No. So first of all, there are two aspects to it. First of all, you have to make sure it is admitted. Once it is admitted, uh, the admission is a question of procedure. Then the question of fact comes whether the content is relevant in this context. So when you send the email, at what particular time you have sent the email, or what is the subject of the email, what is the content of the email, do you have any other corroborations? Just having single email won't be sufficient enough or a conclusive enough proof to determine any issue. You also need to have other subsequent evidences to what you call support your email as an evidence.
Okay, I have one question. If the evidence is perishable, or maybe it will not available after certain period of time, suppose like a bite marks. So, what is the condition we can introduce it in before court? Because if it the case get delayed, that evidence maybe not be available after some time. So, how can we introduce that evidence before the court?
So when you say something is perishable, there was a classic case actually where an ice pick, you have an ice which is water which is made into ice, and that was used as an instrument to kill a person. Now after some time the ice got melted away and you did not have the murder weapon. Now how there was a real issue of such kind, so your bite marks are also similar to that. So there you have to prove to the court, first of all, something of this event has occurred. So no event occurs out of vacuum, right? So before that event something has happened. So bite mark is a uh, assault on you, means it's a physical assault on you. So you should be able to say what happened before it, what happened after it, and if you are able to make the court understand that during this chain of events from A to B to C, this was the action which was very much probable and no other possibility could have been possible, then court will believe you. So this is called circumstantial evidence. So we have to use circumstances to build that situation and present it to the court. And as a prudent man, if you see the section 3, what is the definition of evidence? Sorry, proved, it clearly says that as a prudent man, if I see this sequence of events and I will act on those, then it is considered to be proved. And if the court also sees, okay, he has actually was there at that place, then he again went out of that place, in between so and so happened. And if you are able to establish that, then yes, even something which is perishable can be proved.
Okay, thank you.
Raghav, we have three more questions on YouTube. A mutual agreement was signed on a A4 paper signed by the advocates of both parties along with respective advocates. The original paper is with police and they lost it. So now can a photocopy of that letter is substantive?
Yes, this under section 65 of the Indian Evidence Act, which is called secondary evidence, 65 to be specific, section 65C, where a Xerox copy or a photocopy of such document is admissible when the original has been lost or it is very hard to retrieve or any other circumstances. But you have to prove to the court the story behind it, claiming that so because at the time of admission, it won't be a problem. The court will accept your Xerox under section 65C. But subsequently, the other party can actually rebut your evidence, saying that there is nothing of such kind. But you have to prove to the court that there was such piece of evidence or such piece of document which was actually agreed upon, and you have to bring before the court.
Okay. And there's one more concern. One hacked my phone and collected data. If they produce those screenshots and audios, how will they prove it in court? Certification in section 65B, how they certify?
So, first of all, in Indian Evidence Act or any in India, we could actually put even illegally or stolen document as evidence. Okay, so let us say he was your opposite party. You have the defense of rebutting him, saying that you have got this information through illegal means, but that is not good enough defense. You should also claim that there is no 65B certificate. Those are not your records to begin with, or they have manufactured those records. But now, if I am on their side, what I would do is I would actually comply with the 65B certificate. I would actually show that there was no tampering of records. I would actually show that yes, I was able to record these things stealthily, but that is a different case altogether. If you want, you can file a different case, but those are relevant to consider the matter in issue or a fact in issue in the present case.
Okay. Yeah, the next question is related to DV, the Domestic Violence Act. Does defense need to prove its case or prosecution need to prove its case? What
So,
if it's only oral evidence by prosecution?
First of all, in DV, which is a domestic violence case, it is a summary trial case. 125 CRPC domestic violence are summary trial cases where they don't go deeply into the evidences at the initial, what you call the interim order stage. They generally go by the oral evidences because for them, they have to give an immediate relief. When you say summary trial, there has to be immediate relief. But subsequently, when you have to prove that there is a domestic violence, the person who is aggrieved has to prove to the court, as you have done in any criminal case, that there is a beyond reasonable doubt that there is an offense occurred. Because otherwise, what happens is this person who is accused of doing such thing has to be providing so many other reliefs like residence order, maintenance, compensation, as well as if he doesn't do that, he has a chance of being jailed also. So if you consider that, which is a DV is a civil relief in a criminal procedure with a criminal procedure. So in the interim stage may not be so relevant. The oral evidence could be sufficient for interim, but to prove the case or to bring the case to finality, you still have to prove beyond reasonable doubt.
Okay, Raghav, we will come to the next questions in the next break. Yeah, you can continue now.
Okay. So presumptions. Presumptions is so as we already discussed. So there is something called fact. There is a fact in issue. There is an evidence, and it has to be proved or disproved. But there are certain places where the court presumes something. Why are presumptions necessary? Because let us say I wake up in the morning. So generally, after I wake up, what should I do? I generally brush my teeth, or there is a expected natural way of doing things. So after you kill a person, or sorry, it's a bad example. After you wake up, you generally wash your face, or you have a cup of tea, green tea, whatever. So there is a certain level of presumptions which Indian Evidence Act has given to the courts. It's a discretion to the court so that it makes the process streamlined, simple, easy, quick. So, so there are three kinds of presumptions: may presumption, Court may presume a fact. For example, a child is born within 280 days of separation of a couple. The court will presume that the child legitimate father is a person who was there with him, with the mother of the child. But it's a presumption where the court believes it is true, but the court has a discretion to call for proof. No, I may presume, but I want to prove for it. Or the defense would come and say it can disprove it, saying that no, sir, on so and so time I was not there, and this is the proof for it. So, may presumption is a very weak kind of presumption where the court assumes it is proved, but it has a discretion to call for proof, and the defense can always disprove it. Shall presumption, the court shall presume something as proved. It shall prove it. It's a more tighter bound than may. It cannot call for any proof for it, but if the defense wants to disprove it, it can still disprove it. Conclusive proof. Court shall on proof of a fact. It will assume it is proved, and it won't even allow any evidence to be given for the purpose of disproving it. This is even a very strict. So, for example, if I found someone guilty of committing a murder and I have a conclusive proof for it, that becomes a very strong ground to convict him under so and so provision. But again, there is a small so DNA evidence trumps over conclusive proofs. So courts in certain cases where there is a parentity in question, or where there is a criminal element in question, has relied upon DNA because of the advancement in technology and accuracy in DNA fingerprinting. They have started believing that even if something is considered conclusive proof as per the legislative intent, there are certain things which can be disproved also. So there are a lot of vacant spaces within the may, shall, and conclusive proof, so that we can still uh, fight our case in a fair manner uh, against the state. So now we come to the relevancy of facts. Till now we have discussed about the definitions of uh, the the various elements in Evidence Act. Now, if you want to bring certain piece of information onto the table of the court, it has to be relevant. It has to be relevant to the fact in issue. Otherwise, it is not at all relevant, and court won't even consider that. When such is not even considered, nothing can be decided on that fact. So it has to be proved that it is relevant to the case. So evidence may be given of facts in issue and facts relevant, and no others. No others. Highlight this word, no others, for yourself. So generally it is seen the prosecution tries to bring in some unnecessary evidence into the court, like the character of the person. They say that, okay, this person has defaulted on his check, he's a very bad person, and he has been doing this for others also. So how do you do that? So the first thing any defense should do is rebut, rebut, rebut. Whenever any evidence is put, any kind of evidence is put by the prosecution, rebut it. It can be true also, rebut it. Why? Because if you rebut it and that matter goes on record, tomorrow, even if you're convicted for reasons beyond your control, maybe the prosecution was wrong, or there was a mistrial, or there was any other influences. Now, when you appeal to the higher court, those evidences which you have rebutted will become question of law. Then the appellate court will see, why is this particular evidence even on record? When this person has rebutted very clearly, then you can prove that there was a mistrial in your case. So uh, for any fact to be put on record, it has to be very relevant to the fact and issue. Fact and issue is something which there is a conflict in. For example, I killed a person. Whether you have killed a person is a fact and issue. And the relevant fact is, after you killed a person, you went to so and so place. Is that relevant fact? Means is that connected to it or also? And no other facts. Let us say after so many days, you say that no, this guy, we found him in Banaras, whereas the murder happened in Hyderabad. So you cannot bring that fact into the court. So you have to always rebut. This is mantra. Whenever you are a defense guy, you should always use this. Rebut any evidence, you have to rebut. That's all. Means that will help you in long run. Not that you are actually wasting the court's time or something, but you don't know what can happen if you accept it blindly. So it's better to be on a defensive side rather than a proactively accepting whatever. So the other problem is if you accept anything, once you have admitted it that you have done so and so something, it becomes very hard to reverse that situation. Okay, so kindly, if you whenever there is a evidence against you, rebut it on whatever grounds you have, but rebut that. So there is something called relevancy versus admissibility. So relevancy is logic and probability. Means, is it possible that event has happened? Is it possible that he has really killed that person? Is it possible that he has raped that person? Is it possible? Did he really mete out cruelty to his wife? So, like, you have to produce evidences which actually show this. This is a logic. These are real facts. These can be brought into Section 5 to 55 of Indian Evidence Act. What is relevant has to be proved again. So these all are, so just bringing them into the court won't be useful. These have to be proved also. Admissibility is strict rule of law, whether the court will permit this evidence to be useful or not. So let us say admission to a police officer under Section 25 will come later is not admissible. So there is an accused person. He was actually made to confess to his offense to a police person. That particular confession is not at all admissible. So this admissibility will reject that particular fact, means that particular evidence, if something is brought to the court. Fact which is relevant is not necessarily admissible. Okay, here is the beautiful thing. So I had a communication with my lawyer. I told him the fact that okay, on so and so day I was there. I was the one of the accused, one of the person who has committed that crime. Let us say he accepts and confesses to his lawyer. It is a relevant fact. The lawyer has the information which is relevant to the case, but it is not admissible because of the privilege between the lawyer and the client. Facts which are admissible are necessarily relevant. So something which is brought onto the court, that means it is admissible. That means it has cleared the filter of Section 5 to 55. It has become admitted to the court and is put on record. So it is necessarily relevant. So it can be relevant. It is not relevant, but it can be relevant. So the best test for admissibility is if it is relevant, it should be admitted. Simple. If it is relevant to your case, it should be admitted. Simple. For example, you are having a matrimonial case. Your marriage certificate or your marriage photo is a relevant evidence to even start a 498 case or even start your domestic violence case. Generally, if you see any of those matrimonial cases of like domestic violence or divorce or anything, they only have the marriage photo. Why? Because that is the first place where the court can consider whether the sections of domestic violence or 498 or any other things will apply against you. So those are relevant and those should be admitted also. I'm going to new second section thing. Are there any questions we want to take care?
Yeah, Raghav, we have one question from Bharat. If we have doubt on wife's character, can we ask for CDR through court in CRPC 125? Is the CDR enough to prove adultery?
CDR cannot be enough, Bharat, to prove adultery. It means it will only show that the person is at so and so place. But you need other evidences also to prove that she was with any other person who was male, who is of her means what you call the relevant age. You can't say that she is with an old man. So they will come up with all those sorts of reasons saying that this is not at all useful at all. So CDR is not enough ground, but it can be corroborative evidence. Let us say if you have any other evidence like the chat messages or if you have any photos, now the CDR will show you that at so and so point of time, along with these photos, you can prove that there is a circumstantial evidence good enough to say that yes, she was in a relationship which was out of her marriage, and there is no other possibility. If there is no other possibility which can be shown, then yes, CDR becomes one of the crucial evidences or substantial evidences to help him get whatever relief he is trying to get. I'll move forward.
Yep, please, Raghav.
Yeah. Question of relevancy is a question of law, and it can be raised at any time, even at appeal. So remember, when we were trying to introduce, or a prosecution was trying to introduce any evidence, we said we have to rebut it. Why? This is where we are. So you are convicted for whatever reason. Now you go to the higher court. You can appeal. Now there comes a question of relevancy. Why was this particular evidence also brought in? It is not question of fact. It is the fact is not disputed anymore. It is question of law. This evidence should have not been admitted, but you have admitted that evidence. Because of that wrong admission and your decision based on such wrong admission, you are convicting him. So let us say the police confession was taken and the person was convicted in lower court. Now he appeals it, he goes to the higher court. Now the higher court sees that under section 25 of the Indian Evidence Act, any confession made to the police should not be proved. It should not be used at all. And the lower trial court has done a wrong trial. It has done a mistrial. So now he gets an opportunity. Now, when such thing has happened, he will be acquitted directly. Even one particular wrong has been proved against the guy who is convicted falsely. It becomes a very good ground for his acquittal. But if evidence is relevant, but proof is improper and evidence is admitted, no objection can be taken afterwards. So this was the case where we don't have an evidence right now. The second evidence, like we have a Xerox copy and we don't have the original copy. So it can still be admitted, but it has to be proved later. So that's what we told about the loss of primary document. So we talk about the real windows through which we can bring in evidence or stop evidence. Section 6 to 55 is the gateway where you try to bring in evidence or you stop evidence. Res gestae is like those facts which form the part of same transaction. Example, generally wives say, sorry, in matrimonial cases, there is a case where the husband or wife says the person has deserted him. When you say the person has deserted him, you have to prove that the person has deserted you for the past 2 years. How will you prove it? On so and so day, the person has left you. And after that, you had a communication with him or her where it clearly claimed that I am not interested to join you back. So that is that forms part of the same transaction. And it is an exception to hearsay. Hearsay is like, okay, I heard from there, but no. Let us say even there is one more person who is who has seen that event happening, like the husband or wife has left the spouse, and he has seen it on so and so day, and he can come to the witness box and say, "Sir, on so and so day, this person has left the home." That becomes good enough evidence to be admitted for the purpose of only purpose of what is asked. For example, to prove desertion only, not to prove cruelty, only desertion. Uh, Facts which are cause of effect. For example, so after an offense or after an event, there are certain cause or effect which happens. For example, the classic cases. As soon as you file a 498 case, you are arrested or a bail provision starts. So if you are able to prove to the court that a false case has been registered against you and you were arrested, the effect, which is the arrest, can be used. Such document can be brought into as an evidence in your diverse proceedings if you have. So that is evidence there. Motive, motive is one of the important criteria. The preparation or previous and subsequent conduct before an event or after an event, the behavior of an accused or behavior of the witness becomes an important piece of evidence to decide the case. For example, the witness who was brought in was not even there; he was somewhere else. Now the police or prosecution brings some certain Tom, Dick, and Harry to say that this guy was there. Now, if you are able to prove that that person conduct is not at all proper, the witness he was not even there. How can he be a witness? So that proof, which proves that that person's existence or non-existence at that point of time, is admissible. Uh, Things said and done by conspirator in reference to common design. So this I brought in because common design or common intention, we see that many cases, especially in matrimonial cases, section 34 is applied, where the father, mother, husband, sister, everyone is roped into and put under section 34. The section 34 intention is all of them have conspired against the person and acted in unison to cause the ill against that person. And if a case is proved against one person, the same punishment can be applied to others, even though they were not actively participating in the uh, such offense. Like you could say that there are two dacoits uh, who come and do robbery. In that process, one dacoit kills another. These two dacoits were caught, and one of the dacoit confesses that I have we have robbed that place, and the murder happened there. Now, this particular piece of evidence is such a conclusive piece of evidence, it goes against the other co-conspirator, and it can be used as a confession against him. So that is the reason I brought this. So this also becomes a good evidence for the prosecution to bring in. Facts showing existence of state of mind or body or feeling. So basically here, this is the mens rea. Mens rea means there is an intention to do an ill will, or there is an intention, there is a premeditated state of mind. So which is shown, like before an event, I go and purchase lot of hardware, like very sharp elements to actually, after, for example, I go to a hardware shop and buy a knife or buy a hammer, and that particular instrument was used to cause or hurt or grievous hurt to a person. So that state of mind, if someone has seen him, okay, I as an observer see that, okay, this I am as a shop owner, I say that this guy has come to my shop and he has brought this is the receipt of this. That shows the state of mind of that person who has caused the offense. uh, so this is a facts bearing in question where it is accidental or intentional. So if you can bring out something which you could say that, oh, no, it was an accident by which I had to do this event, or it was not intentional, or it was intentional. So facts bearing that information. For example, you are a doctor, and there was a death, accidental death due to what you call the wrong admission or extra admission of a medicine. Though it doesn't come under the Indian evidence, sorry, it goes to the medical council process of adjudicating him. But I choose this example because those kind of accidents are very common there, and that proof of accident can, if it can be brought on to the court, then that would be a very relevant piece of information for your acquittal. Admission. So admission is one piece of evidence we talked about previously on estoppel. Let us say I admit something, I cannot go back on that. If I go back on that, that means I am perjuring myself. I am telling wrong to the court. I am misguiding the court. So remember, before you admit anything, be cautious what you admit and what. If you don't admit, that is fine. That is no problem at all, because it is up to the prosecution to prove that you have done something. But if you admit, then you have to stand by that word. going. So this is one important section in Indian Evidence Act. So the purpose, if you see, most of the cases in our courts generally end up in resolving amicably. So court provides this opportunity also. Indian Evidence Act also provides this opportunity. Let us say there was a agreement, mutual agreement to stop all the what you call litigations between two parties in civil cases, and they admit to an understanding. Now tomorrow, one of the party goes back on that. So whatever he has admitted can be used against him, but whatever the other party has admitted cannot be used against that person. The purpose of this section 23 was to cut down any litigation. So in that way, you don't drag on the case. That is the whole purpose of section 23. This is one of the important area where everyone needs to focus on: confessions. Confessions are not admissible as an evidence to be proved. If a big if, when there is an inducement, threat, promise, or threat or promise for which are irrelevant to the criminal proceedings. So if someone tries to what you call, if you see any bail order, it is one of the primary conditions that you should not influence any witness, you should not tamper any evidence. But if an accused uh, if an accused is confessing to a police due to a threat or due to fear of life, such confessionary statements which were made to any person are not admitted. There is an exception to it, that is section 28. We'll discuss that. Confession which are voluntary and not retracted even at the later stage of trial and accepted in the under examination of 313 CRPC are fully relied. So confessions are a very good piece of evidence against the accused. So remember, when you confess something, that becomes a very good, because we know that admission is a really good piece of evidence against you already. Confession, confession is confession of the offense or fact in issue. There, it becomes very stronger. Now, tomorrow, if you are able to, if the confession is not retraced, or you did not become a hostile witness, and you have accepted when there was a questioning by the magistrate, he'll ask you your side of the story in 313, and you say that yes, so and so happened, I was involved in it, and I was one of the co-conspirator or the person who has done the event. Then that confession becomes a very strong confession against you, and you could be punished as per the law with that confession, because it is a very uh, a good proof against you, as conclusion, substantial proof against you. Judicial confessions under 164 statements are very strong evidences. So you are coming to the court and in front of a judicial magistrate, coming and telling him so and so event has happened, and you're confessing him. So when you do a confession before a judicial magistrate, there should be no police officer. It's only you. Under total voluntariness, you should be able to make that confession. And this is a strong piece of evidence, and the judicial magistrate will not be summoned to prove that such confession is there. Extrajudicial confession is a very weak evidence. This extrajudicial confession is a confession to any person other than the judicial magistrate. It can be police, it can be any stranger, it can be to anyone. None but judicial magistrate. It's a very weak type of evidence. It's a good evidence, but a very weak type. It cannot be totally relied on. But if it inspires confidence to the court, then it can be used as one of the primary piece of evidence to convict you. Now coming to one of the common thing which police try to do is they give you a piece of paper and ask you to write something on it. Confession to a police, not to be proved before or after investigation. Any confession to any police officer who is investigating, police officer Remember, and who is police officer is a person who is investigating under 154 when you file an FIR, when you do the investigation. But for NDPS, like there are some special acts of NDPS and UPA, they have a different clause altogether. But let's confine ourselves to plain vanilla IPC and cognizable cases where confession to the police officer should not be proven and should not be admitted. If you admit something and based on that you have convicted someone, then it is a mistrial. You are bound to get acquittal in the higher court. Confession when in custody of a police should not be proved. So it need not be to a police. You are in a prison or in a custody of police and you make a confession to some other officer like the judicial magistrate. It is also not a proper confession because you are still under the threat of police, threat of any physical or mental harassment from them. I'll just pause here. If there are any questions, right now we are at 7:40. Are there any questions?
Yeah, we have one question. Something is recorded by digital voice recorder and a transcript has been made. But if we fail to open the recorder, will it be still admissible as evidence, though matter is also saved in other medium?
Yeah, it can be made to admit with relevant 65B procedures. But if you don't know the content of it, again you have a two-step process. First, you have to make it admissible. Then, after admitting it, whether the content is relevant to the fact in issue or not, then it can be used to trial the matter. Yeah, that's all. I'll go forward
Yeah,
then.
fine, fine.
Okay, so how much information? Oh, I think I moved forward. Okay, let me just go by section 27. How much information received from the accused may be proved? So we have already discussed where a confession to the police are not admissible, but confessions where there is a discovery of a murder weapon or document in discussion can be relevant information which can be taken out from the confession. So that is still a relevant information which can be admitted on court of record because it shows a chain of events which were happening. Now, as we discussed, a confession which is involuntary, which is under force, threat, coercion, cannot be admitted. But if it is voluntary, it can be admitted. That is what Section 28 says. Section 32. This is one of the common or popularly known as dying declaration. Uh, in a rape case, the famous case of Delhi rape 2012, where the dying declaration of the woman became a very substantial piece of evidence to convict the four accused or five accused. So, but dying declaration has to be cogent. It cannot be any random declaration. Dying declaration also can be questioned because it being the last piece of evidence where the person cannot be cross-examined again, it is given more weightage. But that doesn't mean that dying declaration is very what you call conclusive piece of evidence. It's a substantive piece of evidence which can be used and it can be taken into the court. Uh, and relevancy of entry of public record. For example, the marriage registration, the date of birth. So those records are admitted into the court of law under Indian Evidence Act because those are public records. Those have been heavily vetted, and something if someone tries to fudge them, it is very difficult. Or that would be one more cognizable case. So those records have high public, what you call admissible value and relevancy value based on whatever section we are dealing with under IPC. Previous judgments are relevant to bar second suit or trial. For example, a person has second FIR or similar question is decided like maintenance or 125 or DV with similar set of facts and similar set of circumstances. Then previous judgments become relevant piece of information and they have to be introduced for the accused. For example, in 125 CRPC, I've got maintenance order. And now in DB, she's again asking for similar, or a woman is asking for similar relief. Now, the previous judgment in 125 can be brought under the court through this Section 40 of Indian Evidence Act, and it is that admitted and relevant uh, evidence. Yeah, going to 44, fraud or collusion obtaining judgment or incompetency of the court. If we are able to prove that there is a collusion in obtaining a judgment or incompetency of the court, then that kind of information can be admitted to the court, and that becomes a very crucial information to acquit a person who has been convicted because of them. Okay. Now, one more piece of important area is expert evidence, opinions of expert. We have seen that handwriting or ballistic or what we call pregnancy test. So there are certain areas where we don't have witnesses, we only have these documents or something or circumstantial evidence, but those cannot be used good enoughly to acquit or convict a person. Then the court can bring in experts, or you can bring in your expert to prove your side of story. So to bring in such kind of an expert, first of all, what you need is, first of all, you have to prove that that guy is an expert. So you have to bring the testimony of that expert, whether he is relevant in that field or not. Then the witness, then if the evidence or if the statements given by the expert are truthful or not. So this is very important. So, but because experts come in place where it is not possible for a common man or a prosecution to conclusively say that there is a fact in issue which can be handled. But the opinion of expert cannot be the alone evidence. It is highly unsafe. I can buy an expert. I can create an evidence. We have a lot of RMP doctors in villages who behave like doctors. We cannot believe their statements or their value as an expert opinion. So it is highly unsafe. So it is always recommended, and the court always sees that there is an other collaborations, other evidences along with expert. Opinions are one of the weakest evidences uh, which are relied, but with other elements as well. So this is one of the important common thing called narco test. People say that, okay, tell me, put me to narco test or let's put him to narco test. In Selvi versus State of Karnataka, the Supreme Court has clearly mentioned that narco test is cruel, inhuman, and degrading. You cannot put a person through that kind of torture where the person doesn't even have control over his body. We have seen the famous Arushi Talwar case where the parents were convicted and the other person who was the maid in that was acquitted. There, narco test was applied. It was considered that it's a conflict with right to fair trial. So it has to be fair to both parties. Just because he's accused doesn't mean that you could go and torture him, you cannot go and manhandle him. So it is only one piece of evidence, not substantial, but courts have to be very cautious. And now, point number 53, section 53, it's a very good information which we have to bring in case of criminal trials. Previous good character. Let us say a person has a very good character, he's a reputed person in so and so organization, or he has been a regular taxpayer, or he has been doing all his activities in a legal way. And so, if there is some criminal case against him, that becomes a very good document because the character of a person in case of criminal trials becomes one of the crucial pieces where you could say that that person has done under the influence of alcohol or he was under private defense, so and so could be adduced. So this becomes an important piece of evidence to help his acquittal. So coming to rule of best evidence,
I have one question here.
sure.
The bad character can also be used as evidence.
No, bad character cannot be used. Bad character can be one, what we call, so good character. So ours is our judicial administration system is not just, it is not retributive. We believe that a person can become good person after proper coaching or proper what we call procedures in the prison system or something. So bad character is generally given a lower weight than the good character. But if he is a repeated offender, then that information can go against him.
Okay, thank you.
Yeah. So the rule of best evidence is we have to remember in our criminal jurisprudence is accused is innocent until proven guilty. He is not guilty till he is proven. And it has to be proved beyond reasonable doubt, not mere preponderance of probability or imposing obligations on reducing the just not just okay, it is possible that he is not guilty. No, no, no. It's possible that he is guilty. No, no, no. He has to be proved beyond reasonable doubt. Yes, he has the one who has done such crime. Why? Because generally the prosecution doesn't bring such evidences, because if it brings such evidences, it will have something which could be benefiting the accused. So the prosecution generally doesn't bring the best evidence always. It always tries to bring out some other piece of evidence through which it will try to prove that you are guilty. Because if it brings the best evidence, it not just also proves that you have done so and so thing, but you have done under so and so circumstance. So failure to bring the best evidence makes the prosecution vulnerable. So adverse inference can be brought in by the court. So court can say, okay, you are not providing the best evidence. Given this evidence, we cannot. The only possibility for us is to say that he is not guilty. So it is on. So you have to make sure as a defense that you have to push the prosecution to bring out the proper evidence. Court can presume the existence of any fact if it thinks it has occurred in common course of natural events. We have spoken about the presumptions, right? So court has a huge discretion in presuming that so and so act can be possible regarding a common natural course of events. For example, there is a CCTV footage showing that this person has walked to that place. So the court can assume that okay, this guy was at this time was at this place in A. Now after 10 minutes he was at place B. So that is possible. So court can presume. Uh, Circumstantial evidence we discussed about it. I'll get more into that now. Every circumstance has to be proved through reliable and cogent evidence, which can form a chain so complete to exclude every hypothesis except the guilt of the accused. Circumstance cannot be any circumstance. It has to be circumstance such that no other option is available for the court to imagine other than he doing that act which caused that person to be guilty of such offense. So it has to be excluding all other possibilities except for the event that he has committed so and so offense. Separation of evidence entitles courts to draw a adverse inference. So the rule of best evidence says that even the circumstantial evidence says that we have to push the prosecution to bring in the proper evidence. It is their responsibility. If they're not able to do their job, how can you be guilty of such offense? So I'll just end with two more slides. These are important tips I considered. I just covered only the admission part of the Indian Evidence Act. There are other pieces of information like the cross-examination, oral evidence, public document, which I'm not covering because it's already quite late. That can be another session. But these are some important points which you should always remember. Get all your evidence on record during the lower court. Everything should be on record. It should be in writing. Rebut all the evidences of the prosecution. Remember to apply general defense under IPC section 76 to 106. What are those defenses? Mistake. You have done an act by mistake. That was an accidental mistake, or it was under necessity or compulsion to avoid a greater harm, or the accused is a child, or the person was a drunkard at that point of time when he had done such event, or for example, the great case of 376, there is a consent by the woman, then only be involved in the act. Otherwise, there could not, if there was no consent, why will I go to such an extent? Good faith. I try to avoid I try to avoid a greater harm, and in good faith, I try to do things. Triviality. This is a trivial matter which they are trying to bring into the court, which has no bearing on the case. Private defense. This is one of the very good. Private defense is defense against body and property. If someone gets into your home and tries to steal, uh, you have, according to the law, all the powers to defend your property and your life. But to the extent the harm which could have been committed if you have not defended, you cannot just kill the person whoever comes into your home without your permission. You cannot do that. But if the person puts through a sharp instrument, tries to hurt you, then yes, you could actually take a step which will avoid that. In the course of action, the person could have been hurt or previously hurt, or death also can happen. So these are the general defenses you should always remember in your criminal trial. For example, there is a 498 a case where they claim that there was a cruelty against a woman through so and so instrument. So let us say there was an accidental hit of a person also. Then you should say that there is an accident. It was one of such case. It was not a regular common thing. But like these are the general defenses which any person should apply or should know of, because most of the cases these kinds they come into these buckets. So, but remember it, a burden of proof is on those person. The burden of onus we had discussed as one of the questions. Remember, so the burden of onus now is on the person who takes these defenses, and court assumes or presumes they were not at all present. It was not a mistake, it was not an accident. But if you are able to prove it, then good. The right available even when you're not pleaded before the court. Let us say the accused did not plead that he was drunk on so and so day, but the court found out that this person was a drunkard. He was a regular drunkard, uh, and on so and so day also he has drunk. Then the court, suo moto, can bring out this what you call general defense, and he could acquit them also. The test, it is only to turn the balance of probabilities, not beyond reasonable doubt. So the person who invokes this general defense, he need not prove it beyond reasonable doubt like the prosecution does. He just needs to bring a doubt in the mind of the court, saying that no, he could have not done that. You just need to bring the doubt in the mind of the court. If you are able to succeed in that, yes, court will assume that there is a possibility, and it could take this defense and acquit you also. Admitted facts need not to be proved. So let us say I admit, you admit, those need not be proved at all. So remember not to admit anything which you don't want to regret later. Don't admit any fact which you will regret later. It's better to say I don't know than I know. So when you give an evidence or anything, be very specific and clear. Don't waste the time of the court. Give the time, place. So in the court's eyes, you have to respect the court so that they will appreciate you. Because we are expecting justice from them, and they are also human beings. We should also play according to their rules. Preponderance of probability we have discussed. Uh, uh, so yeah, so I won't go much into it. Uh, Now, this is one exception to the Indian Evidence Act, Section 14. Uh, Section 14 of Family Code 1984 empowers the Family Court to take any evidence beyond Indian Evidence Act. So in Indian Evidence Act, under Section 5 to 55, there is something called admissibility. If something comes within those clauses only, they can be put on record and the court can decide the matter using them. But family court has something extra power. It has a superpower, where under Section 14, it can bring in any other evidence which can help in what you call dealing with the dispute. But it's a very there has to be a lot of care and safeguard. Why they have put this in the family court law is most of the time it's a private matter. Family is a private matter. Everything happens within the four walls of according to them, and they don't want to make a family issue a bigger issue. That is the reason they say the court safeguards which have to maintain it. It has to be extremely circumspect. What evidences it choose to rely on. So you could actually provide certain what you call the intimate photos or something which is very what, for example, we have seen the recent Shabarimala case. The woman actually brings out photos with her children. So like court is very extremely circumspect when you bring such kind of evidences. So it will restrict it, and the court will restrict. Maybe it can allow an in-camera proceedings also. But if it finds that such evidences are very what you call offending the mind of a person, of a common man, regarding to woman or a child, it can initiate a legal action against him. The classic cases, let us say, in your what you call 498A, where DP3, DP4 case is there, and you were somehow able to prove to the court that you did not demand any dowry, but you were given dowry. Now, at this point, court under Section 14, if you can bring such evidence, it can initiate the legal proceedings in DPT provisions against the person who has given the dowry. I just give an example. Yeah. So that's where I end. There is more to the Indian Evidence Act. Because of the paucity of time, I'm not going into them. Maybe I can do one more session later. This is my email address, and please visit mynation.net for further information.
Thank you, Raghav, for wonderful session and very informative and helpful.
Yes, sir. Can I stop my sharing?
Yes.
Raghav, we have few questions actually.
Sure, yeah.
Yeah. Can court use lie detection test in matrimonial cases as 498?
No, it is similar to narco analysis. It cannot.
Okay. Another question from Venkat. For false 313 IPC, opponent produced fake medical pregnancy abortion certificates. Is court can consider her medical certificate only as evidence or ask for more evidence like husband's presence, husband's DNA test, etc.?
First thing, you have to rebut that evidence. You should not even allow that evidence to come on record. Now you have to tell to the court that such evidence is incorrect evidence or false evidence, and it doesn't. So yeah. So because she's telling that the pregnancy was dropped, that is a section, and that is the evidence she's bringing in. Now you have to question the quality of the evidence, whether the doctor who has given the prescription was he valid medical practitioner or not. So though it could be admitted, but it cannot be relevant. It can be disproved by you later stage. Yeah.
Okay. Thanks, Raghu. That's all from the channel. Any other questions from our team?
I want to know what's the rebut process means. Suppose if somebody that opposite party present one evidence, so now I have to rebut it. So what's the procedure in front of court or in front of judge?
So when someone tries to adduce evidence into the court, he does through a memo or through so and so section in a court. Then the court will because it is an adversarial system, you should also be given such copy. So at that point of time, you should be telling to the court, sir or madam, honorable judge, This is not a relevant piece of information, and this is not admissible under section 5 to 55. If you are able to find a section under 5 to 55 where this kind of evidence should not be brought in, or there is a procedural lacuna which it was there. For example, if there is an electronic evidence and they did not provide a 65B certificate, then so, or if there are like confession to the police which were brought in, then so you have to find any of those procedural lacuna, or if they are not admittable or they don't have relevance, you have to identify those things and rebut immediately in front of the judge. You should say this is not admissible and it will be detrimental to me and my client. And then you can give a written reply also, so that that gets recorded into the court records, so that even tomorrow when the court tries to decide your matter based on the adduced evidence, then they will see your rebuttal. You will say that no sir, this should not be required, but you still admitted it. Now let us say you are convicted also, you can go to the higher court and bring out that evidence. That will be a useful point for you.
Okay, thank you.
Okay, Raghav, I have a question.
Sir,
Most of the time, when 498 or DV or whatever false case is filed, whatever woman says, that has taken as a valid statement without any evidence. They are not;
yes sir.
those are not supported by any evidence. How to counter those false allegations if there is no evidence or supporting document or anything? Because most of the time, judge blindly take such stories. They admit, but when man submits some document, also they refuse to take.
Yes, sir. So
They are
first
not
of all,
admitting.
yeah, you are absolutely right, sir. Given uh, our legal system is yet to move fast in that area, but there is one thing what we have observed is in the initial, in the beginning, or till the interim order is given, court generally believes the woman based on her word, and it sees a prima facie case because they have instructions as such to be very what you call it, because these are social laws like 125 or domestic violence. These are very social what you call it, social remedies. They want people not to suffer. That is their objective, where they actually try to be favorable to the woman. But later in the stage, when you are trying to bring in evidences, so you have to make sure all your evidences are on record, so that even though the court rejects your evidence. I have seen some people who say that my evidence is not getting accepted by the court is rejecting. Then ask the court, why are you rejecting? Make the court work. If they are not able to do work, you put as a memo, bring it on record. You can actually complain to the higher authority, means higher court, or when in the appeal, you can always get a relief where the higher appellate court can provide instructions to the lower court saying this is bad in law, this is not how the law should apply, you have applied it wrongly. But there is a bigger fight, sir. We have to fight it.
Okay,
Okay, thank you.
I have one question on relevancy of fact. In the DV case, most of the time you will see they will mention about some event which happened before the marriage, means when they are not cohabitating. So that should not fall under, I think, in domestic violence case, because that it is not under the scope, because for domestic violence there should be some cohabitation between those two. So
So
that how
that is what we are saying. Rebut. If it is not at all concerning to the matter of the domestic violence, and the matter is concerning to some event before marriage, how can that be accepted at all? You should stop it there itself. You should
okay.
make the court understand it is not at all relevant information. Now you're trying to bring certain piece of information. You're just increasing your paper load. You're just wasting the time of the court. It's okay to be critical about the court, but it has to be reasonable and proper. That's all.
Okay, thank you.
Raghav, we have two more questions. Can
Yeah,
the alleged
yeah. Go on.
accused ask for polygraph test or narco test for evidence upbringing?
Uh, Polygraph test of whom? Of himself or others?
Of himself, yeah, of himself.
Yeah, he has that right. If he wants to violate his own what you call personal liberty, he can always do it. No one is stopping. But against him, no one can invoke.
Okay. And in 406 matter, can a bill of furniture where there is no GST dealer mentioned, can such sort of evidences be approved in the court?
Those are admitted. Because but if there is no, see, that's again I'm bringing that point. If the you should also always tell to the court, sir, this is a fake bill, it's a Xerox copy, or you have to summon the person who has provided you that bill. You have many remedies. You can put 91 CRPC against the person who has provided you such bill. Or when the court is trying to decide the matter based on such evidence, you should always say this bill is not at all relevant. So you should tackle it at the admission phase, you should tackle it the relevancy phase, and if even both of them fail, then bring in the person who has given that evidence. If all these fails, then yes, you have taken the fun. It proves that it doesn't what you call it doesn't disprove that you have not taken, but it is up to the opposition or the prosecution to prove that beyond reasonable doubt that you have taken. So it is their headache. But for us, we are at a upper hand. Means the defense is at an upper hand. It cannot always object. It can always object. It is wrong. It is wrong. It is wrong. You bring in the person who has given you that receipt.
Okay, thanks, Raghav. That's all what we have from our YouTube channel.
Thank you, sir. I concluded like.
Okay, thank you, Raghav. It's a very beautiful piece of information you gave.
Okay.
Okay, thank you, everyone. We'll close this session now. Okay, bye-bye.